लाइव हो गए. Hello friends, welcome in Amit IS Academy. Myself Tushar Shukla, Polity teacher. Today we are going to start a new chapter, new lecture, that is citizenship. It is in a part 2nd of Indian Constitution. And it contains from Article 5 to 11. In this session, we will cover different aspects of citizenship. But before starting citizenship, I want you guys to imagine one situation that you guys are in America. You have arrived there for tourism purpose or for any education purpose. In America, what is your identity? Think about it. What is your identity? Your identity is that you are an Indian citizen. You are not Satish Kumar, you are not Praveen Tiwari, you are not Amib Ranjan. You are what? An Indian citizen. That is your identity in America. That is important of citizenship. What respect you will get in America, that will be because of your citizenship, not because of your name or not because of your wealth. That they will be secondary for you. Primary will be citizenship. So this is the importance of citizenship. Now we will look into what is the definition of citizenship, how we can define it. Its simple definition is that it is a relationship between the nation and the people who constitute that nation. In simple words, what we can say that, for example, it is India. And this is me. Or you can be also there. So what is citizenship? It is a bridge or link between me and my country. This bond is known as citizenship. With the help of citizenship, you get lot of services. Your basic identity is due to your citizenship only. The person are categorized in mainly in two categories, citizen or alien. There are certain rights that country gives only to its citizen, not to any other ones. For example, fundamental rights that are in a part 3rd of Indian Constitution. In this, fundamental rights such as Article 15, Article 16, Article 19, 29 and 30. These are only enjoyed by Indian citizens who are the citizen of this country. These rights are not available to the person who came from abroad or who are foreigner to this country. These article or these fundamental rights are only meant for the citizen of the country. This is the biggest benefit of citizen. And the other important things are that, for example, voting rights, right to hold certain public positions or public offices. These are only meant for the citizen of the country, not for any other person who came from abroad. This is a major difference between or major benefit of having a citizenship of any country or Indian citizenship. And other thing, there are in present world, there are many people who are stateless, who do not enjoy any citizenship. They are facing lot of troubles. For example, we have seen that in Middle East countries, there is civil war condition, terrorism is there, due to which people are migrating from Middle East to European nations, where they are considered as a stateless citizen. They do not have any citizenship, and because of that, they cannot demand for any rights. Okay, because rights are only there are certain rights which are only meant for citizens only. This article we will discuss them deeply in fundamental rights when we will discuss fundamental right in the next session. Here you have to only understand that these rights are only meant for Indian citizens. And how question is formed from this topic? In question they will write you in code wise or simple question also, which of the following rights are only meant for Indian citizen and they are not available to the foreigners. Then you have to write that answer. And these things you can also use in your mains answer writing as a value addition. That will fetch you 1 or 2 more marks in comparison to other guys. This was all about definition of citizenship, significance of citizenship, what benefit citizenship gives to you. I hope everything is clear about this topic, citizenship. Now we will move ahead and discuss about the different articles that are covered in part 2 of Indian Constitution. If you guys have any confusion, please write in a comment section. I will answer those questions. Let's start with the Article 5 of Indian Constitution. It is the first article of part 5. Now the what article says? Citizenship at the commencement of the Constitution. First of all, you need to know what do you mean by the commencement of the Constitution. Commencement of the Constitution means when the Constitution was enforced in this country. And when it was done on 26 January 1950. This was day when the Constitution was enforced in country. You have to remember, because this term I will use several times, then you have to refer to this date only, when our Constitution was commenced. Now what the Article 5 says? Article 5 says that it talks about citizenship. Who will be Indian citizen when Indian Constitution was commenced? Now we will look into article. What conditions were laid down for being the citizen of India? Article 5 says that whoever was domicile of India at the time of partition or in the year 1950, he or she will be considered as an Indian citizen. For instance, after partition, this was, sorry, my drawing is not that good. That's why I am facing problem. For the example, this was Indian. So as per this article, whoever was living in this part or having domicile in this part was considered as an Indian citizen. I am repeating again what Article 5 says. Whoever was living in this territory and having a domicile was considered as an Indian citizen. Now one question may be rising in your mind. What do you mean by domicile? Let me explain you. And this problem you have also, the word domicile you have also listened when you will go for admission in different institute. They will ask you to bring your domicile. So what does the domicile means? Domicile means your permanent residence. For example, I am from Uttar Pradesh. So for me, my domicile is in Uttar Pradesh. For instance, anyone living in a Delhi or Rajasthan, they have a domicile or permanent citizenship. It talks about permanent residence. For example, anyone has got job in America or in United Kingdom, they will live there for 5 years, 6 years, 10 years. So that will be permanent domicile or not? No. Their domicile will be in India because they are permanent residents in India only. So this is the concept of domicile. I hope you understand the concept of domicile. Apart from it, person has to fulfill certain more conditions, such as he was born in Indian territory. You have to, person along with it, person has to fill any one of them. First one is, he should have born in Indian territory. Second, whose either parent was born in Indian territory. It could be mother also, or it could be father also, who has born in India. And the third condition is, who has ordinarily been resident of India for not less than 5 years immediate proceeding of the commencement of the Constitution. For example, Constitution commenced in 1950. So if that person has to be citizen of India, he must have been living in India from 1945. This is the crux of Article 5 of Indian Constitution. Now I think there will be no confusion regarding Article 5. Now we will talk about Article 6. What Article 6 says? Article 6 talks about the people who have migrated from Pakistan to India. Who have migrated from Pakistan to India. This article deals with especially the people who face the problem of that communal rights, or due to their religious issues, they migrated from Pakistan to India. Now, what this article contains? It also specifies certain condition, and the person who fulfills that condition, then he or she will be considered as an Indian citizen. So let's look what those conditions are. First condition is, he or either his parents or any of his grandparents was born in India, and that was according to the Government Act of 1935. Means they should have born in an undivided India, means in Pakistan also. And the more condition that person has to fulfill, it is that person has migrated before July 1948 and has been ordinarily the resident in India since his migration. Now you have to understand why this date is important. July 1948. On this day, India and Pakistan signed the Permit system, on the basis of which people were given permit to either go from India to Pakistan or come from Pakistan to India. That permit system. So people should have come before signing of that permit system. They will be considered as an Indian citizen. And what was the second condition? They have came after July 1948. In that condition, they will be considered as an Indian citizen if they have registered themselves by an officer appointed on the behalf of government. If they have registered themselves as a citizen to that responsible officer, then they will be considered as a Indian citizen. So till now we have seen two articles. Article number 5 that talks about citizenship at the commencement of the Constitution, and Article 6 talks about the people who have migrated from Pakistan to India. Let's move toward the next article, that is Article number 7. Now what Article number 7 says? It talks about the migration of people who migrated from India to Pakistan. It talks about the people who migrated from India to Pakistan, and again they came back to India because first they went there and they thought that it would be like a good country to live, and they later realized that no, India is more better for them to live. So they came back to India. It talks about those people. The people, its first sub-article says, subpart says that the people who migrated from India to Pakistan, they will not considered as an Indian citizen. What it says, the people who have migrated from India to Pakistan, they will not considered as an Indian citizenship. On the other hand, if those people, after staying some time in Pakistan, they have returned back to India and they have registered themselves with a responsible officer who has been appointed by Government of India, then they may be considered as a citizen of India. I hope the doubt about this article is clear now. We have covered 3 articles in now, Article 5, 6 and 7. Now we are moving toward the Article 8 of Indian Constitution that deals with the citizenship. Now Article 8 talks about citizenship of certain person of Indian origin residing outside India. There are a lot of people who are residing in a different countries such as in Mauritius, in European countries, in America, in Australia. So this article deals with those people who can be a resident of India or a citizen of India. The conditions which are given in this article are that any of your parent or grandparent should have born in India, then you are eligible, and along with it you have to fulfill one more condition. You have to register yourself with the diplomatic or consular missions of India in that country. If you will fulfill these 2 conditions, then you are eligible for Indian citizenship. So Article 8 talks about the people who are of Indian origin living in a different part of the world. If they fulfill these conditions, they will considered as a Indian citizen. Now we will move toward the Article 9 of the Indian Constitution. Till now, I hope everything is clear to you guys. If you have any doubt, please don't hesitate to ask anything. Now it talks about Article 9. What is given in Article 9? Article 9 talks about people volunteering acquiring the citizenship of foreign country will not considered as a citizen of India. For instance, if you get good job in Australia and you go and settle over there and you acquire that Australian citizenship, which means that you are no more Indian citizen at all. This article is related with that only. People voluntarily acquiring the citizenship of foreign country will be not considered as the citizens of India. There is no doubt in very simple, it is written in a very simple words. There is nothing to explain in it. Now I am moving toward the next article. It is also one of the most important article. The language of this article is quite complex, but in simple terms I am explaining you to the Article 10 of Indian Constitution says that if you are considered as an Indian citizen under Article 5th, 6th and 7th of the Indian Constitution, then you have to follow the rules and regulation laws enacted by Indian Parliament. You are subject to any law, which means you have to follow the provisions of the laws enacted by the parliament. You cannot say that I am supreme to them. I will not follow them. You have to follow. Being a subject or citizen of this country, it is your duty to follow the laws enacted by the parliament. It is given in the Article 10 of the Indian Constitution. For you guys, I am reading this article so that you can get more clarity. Any person who is considered as a citizen, any person who is considered as a citizen of India under any of the provision of this part, means under a different article of part 2nd, shall continue to be citizens and will also be a subject to any law made by parliament. Means all the law enacted by the parliament will be applicable to person who is considered as a Indian citizen. I hope Article 10 is clear now. Now it's Article 11. Before moving to Article 11, I would like to tell you that sometime match the following questions in state PCS has come, where on one side they have given Article 5, 6, 7, 8. On the other side, they have given the subject of different articles and they have asked you to match the following. You have to choose the correct option. So you have to differentiate between what is in Article 5, what is in Article 5, and what is in Article 6, so that it will be easy for you to do different types of question. And one more question, and now I'm repeating itself, which we have discussed in starting of this lecture. Which articles of which fundamental rights are only for Indian citizen? They cannot be, they are not applicable to the, or they are not meant for the citizen, for foreigners or the people who are living in abroad. You have to write this answer in the comment section. Now we are going to start Article 11 of Indian Constitution. It is one of the most important article among all them. What Article 11 says that? You have to understand. Article 11 of Indian Constitution said that Parliament has right to regulate citizenship by law. In simple word, we can say that Indian Parliament is a supreme body which is given power by the Constitution to regulate the citizenship of country. And how the Parliament do that? By enacting law on the basis from time to time. That different Citizenship Act have been enacted by the Parliament to regulate the citizenship of the country. So if the question comes, which body is responsible for regulating citizenship in India, then what will be your answer? Your answer will be Parliament. In this context, I would like to explain you one more thing. In India, we have a concept of single citizenship, which means you are only citizen of India. There is no citizenship of any state. You cannot see that you are citizen of Bihar, you are citizen of Tamil Nadu, or you are citizen of Andhra Pradesh. There is only one citizenship, that is Indian citizenship. While on the other hand, in country like USA, there is a concept of dual citizenship, where a person is a citizen of a state also, and as well as he is a citizen of union also. So there is a concept of dual citizenship. But in India, in order to promote the unity and integrity of India, we have kept only the one option, that is Indian citizenship. So if there is only one concept, Indian citizenship, and who in this regard, who holds the responsibility of regulating Indian citizenship, that is Indian Parliament. Okay? I hope there is no confusion in understanding Article 11 of Indian Constitution, which says that Parliament has the right to make any provision concerning the acquisition and termination of citizenship and any of matter relating citizenship. which means constitution that parliament will lay down the conditions or provisions on the basis of which one can acquire that citizenship, and citizenship of that person can be terminated on the condition which are being given by the Indian Parliament. So I hope this article is clear now. In Constitution, which is in the part 2nd of the Indian Constitution, there are articles from 5 to 11. We have discussed them all deeply. If still you have any doubt, please don't hesitate to ask them. So we have finished all the articles of this citizenship of the part 2nd of the Indian Constitution. Now we will discuss the Citizenship Act of 1955, which is very important act enacted to regulate the citizenship in India. Now we will focus on the what are the major provision for acquiring the Indian citizenship as per the Citizenship Act of 1955. There are five main conditions for acquiring the Indian citizenship. First was that in Article 5 we have seen citizenship at the commencement of the Constitution. When Indian Constitution was enforced on 26 January 1950, the people who were the citizen at that time, they were considered as an Indian citizen. Apart from this, there are 5 more conditions through which you can acquire the Indian citizenship. Now we will discuss about all those situations or conditions. First is citizenship by birth. If tomorrow you get married and you have a children, they will automatically get the citizenship of this country because you are the citizen of this country, as a result of which they will get the citizenship of this country. And what the second option is? Citizenship by descent. If your parents or grandparents are citizen of this country, as a result of which you will also get the citizenship on the basis of descent. I hope these two conditions are now clear: citizenship by birth and citizenship by descent. Now we are moving toward the next few conditions which are important for acquiring the Indian citizenship. The next few conditions are that citizenship by registration, citizenship by naturalization, and citizenship by incorporation of territory by the government of India. These 3 conditions we will discuss now. First is by registration. For this we will discuss with the help of example. For instance, you have seen that certain people from Pakistan or from that in different countries we have seen, they came to India as a refugee and they registered themselves. What they did? They registered themselves with the government department, as a result of which they acquired the citizenship. And for this, migration should be legal. It should be not illegal migration. Second condition is naturalization. The naturalization condition says that you can become Indian citizen or citizen of this country after staying in this country a few limited, there is some time period for which you have to stay in this country, as a result of which you will get citizenship through naturalization. You have to pass that given time period in Indian territory. Then you will be considered as a Indian citizen. Next is incorporation of territory. What do you mean by incorporation of territory? Again, I will use the example of Sikkim. In 1947, when this country was formed, or even at the time of commencement in 1950, 26 January, Sikkim was not part of India. When we acquired it in 1975, through the 36th constitutional amendment, all the citizens of Sikkim became Indian citizen. And one more example I would like to give you. In tomorrow, if Nepal becomes part of India, you have to just imagine that the people who are citizen of that Nepal, क्या होगा? अभी रुक जाओ 10 मिनट. People of Nepal will be naturally become the Indian citizen. This will done under incorporation of territory. Now I hope you understand them all. Registration, naturalization, and by incorporation of territory. These were the ways of acquiring the citizenship. Now we will discuss the ways through which the citizenship of that any person can be taken away. First comes the renunciation. What do you mean by renunciation? You yourself give away the citizenship of India or any country that you want. For example, I am an Indian citizen and I give away the Indian citizenship. That will be the first way of termination or giving away the citizenship of that Indian citizenship. And another one is termination. What do you mean by termination? Termination is applied when you take the citizenship of any other country. For example, we have discussed few minutes before that if I acquire the citizenship of Australia, then automatically I will lose the Indian citizenship. That will come under termination. And the last measure for giving up the citizenship or for the termination of the citizen is deprivation. We have discussed that under Article 11. Parliament has a right to make provisions regarding acquiring and termination of citizenship. If you do not fulfill the conditions which are laid by the Indian Parliament, then you can be deprived of your citizenship. There are many conditions which are laid by the Indian Parliament. I'm not going in deep because that is a static portion that you have to read by yourself by 𝐮𝐸𝐵 or any other book that you want to. But I will suggest that go through the 𝐮𝐸𝐵 only. That is sufficient for understanding these topics. Now what we have studied? Termination of Indian citizenship. What are the three conditions or the three parameters or the three mechanisms through which a person can lose Indian citizenship? First is renunciation, second is termination, and third is deprivation. Now you are clear about the meanings of renunciation, meaning of termination, and meaning of deprivation. These are all methods or mechanism of losing Indian citizenship. Now we are moving toward next topic. This is from the current topic because it is still in news. Citizenship Amendment Act, which is in short known as CAA. It was enacted in the year 2019. And it was on many controversies. It led to the rise of many controversies in India. In that regard, this act became important to know the important provisions of this act. Why it created a controversies in our country. So we will study the important provision of this act. Let's start. This Amendment Act, first of all, amended the Citizenship Act of 1955, which we have discussed little ago. So what was the main provision of this act was that in this act, 6 religious community, which are those Hindu, Sikh, Buddhist, Jain, Parsi and Christian. These 6 communities who came from Afghanistan, Bangladesh, and Pakistan after facing prosecution or exploitation in these three countries will be eligible for citizenship of India. This provision created hue and cry in the country. People asked why Muslims are not included in this category. This is part of controversy. People have different views over this topic. We will not go in that debate. We'll discuss, or we will talk about only what were the important provision of this act. So which 6 communities were included in this provision? That were Hindu, Sikh, Buddhist, Jain, Parsi and Christian, who were prosecuted in Afghanistan, Bangladesh and Pakistan, and they were now eligible for Indian citizenship. And what was the second important provision of this act was that it amended the period of required for naturalization from 11 to 6 years. Before this act, a person has to stay in India for 11 years to ask the government to give them citizenship to fulfill that criteria. But this amendment reduced this 11 years to 5 years period of naturalization. Now we will discuss the next provisions of this act. The next important provision of this act was that cutoff date for giving the citizenship of people of different religious communities who came from Afghanistan, Bangladesh and Pakistan was kept at December 31st, 2014. What was cutoff date? December 31, 2014. It was the cutoff date. Now I hope you are able to understand what were the important provision of the Constitutional Amendment, Citizenship Amendment Act of 2019. Now we are moving towards next topic. Now we'll discuss the concept of overseas citizen of India. What do you mean by overseas citizen of India? In this regard, many questions will be rising in your mind. Did India have a concept of dual citizenship or not? Or Indian citizens who are living in other countries are also considered as at par with me or any other of this Indian citizen? We will answer this question in this topic only. First of all, we have to know concept of overseas citizen of India. Here we will discuss in the context of OCI card given to these citizens. So to whom OCI card is given? OCI card is for the foreign national who were eligible for Indian citizenship. Here it is saying that, not talking about Indian citizen, who were eligible for Indian citizenship on 26 January 1950 or was an Indian citizen or after that date. They would have been eligible for Indian citizenship or they were Indian citizen at that time. OCI card is only meant for those people. In this, OCI card is not given to the citizen of Pakistan and Bangladesh. It is mainly due to security reasons. And they are not eligible for OCI cards. If, for instance, OCI card is given to any person, did they have voting right in India? Can they hold any public office in India? No. This is the major difference between Indian citizen and OCI card holder. That they are not given the right to vote in India. It is just a honorary title to person of Indian origin who are living in a different countries. It is only meant to facilitate their entry or exit in India in a fruitful manner. We will look more aspect of OCI card. And one more thing I would like to tell you. Like OCI card, there would have been one more card, that is Person of Indian Origin card, PIO card. In the year 2016, PIO card that was merged with OCI card. So we are not studying about or going in deep about the PIO card because that was merged with the OCI card. It is, as we have discussed already, it is not a dual citizenship. OCI card holders are not Indian citizens. It is the only honorary title given to them to facilitate their movement in India. The next important thing is OCI card is a multi-purpose, multiple entry, lifelong visa for visiting India. It is we can say OCI card is a type of initiative that has been taken by Indian government to facilitate the movement of people or to attract them to come to India, to explore India, to visit India, to study in India, to do business in India. This is the main purpose of the OCI card. I hope there is no doubt in that. The next important thing is that person with OCI card have equal rights with NRIs in terms of financial, education and economic matters. In three spheres such as financial, education and economic sphere, they have equal rights with as of that NRI. In comment section you have to write what is the full form of NRI and what do you mean by NRIs. I will discuss this concept in a next session. It is like a homework for you guys to go and Google it. What do you mean by NRIs and why they are important for India? But there are certain limitation of OCI card that they are not allowed to acquire agricultural land in India. This is a major difference between NRIs and person who have a OCI card, overseas citizens of India. The difference is that overseas citizens of India who have OCI card, they are not allowed to acquire agricultural land in India. And what other major difference is that they do not have a right to vote. They do not have what? Right to vote in India. This is what major difference between NRI and OCI card. Now I hope the concept of overseas citizen of India is clear in your mind. This was all about today's session. In this session, we have covered the citizenship of India. What do you mean by citizenship? Along with it, different articles that are covered in the part 2 of Indian Constitution. We have discussed them in deeply and I hope there will be no issues in understanding those articles. Next important thing we have studied, that is Citizenship Act of 1955. After that, we studied the Citizenship Amendment Act of 2019, which is still in current affairs, and question in both PT and Mains can be asked from this topic. And after that, we studied the concept of overseas citizens of India. Thank you guys for watching this session. Please like, share and subscribe this channel and this video. Thank you and have a nice day.